If you love liberty, declare your independence by signing the Shire Society Declaration at shiresociety.com.
Your Honor, report.
You may be seated. Good morning. The next matter before the court is captioned Town of Belmont versus Mike Sylvia. Docket number on this matter is 2018-C-200. Specifically before the court is a hearing on the merits in reference to the complaint for injunction filed on 8/13/2018, scheduled consistent with the notice of bench trial dated 5/6/2019. Would counsel and the pro se litigant stand identify themselves for the record?
Good morning, Your Honor. Laura Spector Morgan from the Mitchell Municipal Group on behalf of the Town of Belmont. With me today is Code Enforcement Officer Steve Paquin.
Good morning, Your Honor. Mike Sylvia, representing myself.
Okay, as a preliminary matter, we've had two requests for audio-video camera use filed consistent with the applicable rule, that's Rule 204. The first is filed by Mr. Mortensen, Laconia's son, dated 10/21/2019. I would note that for the record that this particular request was emailed to the parties on 10/21/2019. Town of Belmont, plaintiff, any objection?
No, Your Honor.
Mr. Silver, any objection?
No objection.
Mr. Mortensen, you ready to proceed, sir?
Yes, Your Honor.
Okay, obviously your request is approved. The second request was submitted by Free Keen. It was submitted today and emailed to both parties. Any objection from the Town of Belmont?
I've not seen it, Your Honor, but no, I don't have any objection.
Okay, it was emailed to you today.
I didn't get it before I came here.
I see. You want to request? You want to take a look?
If I
Mr.
may.
Sylvia, have you got a copy of this?
No objection.
Okay, no objection, okay. Any objection from the Town of Belmont?
No, Your Honor.
Okay, that being the case, Representative Free Keen, you're ready to proceed, wherever you might be. You're
We're good
ready
to go.
proceed, sir?
Yep,
You're all
thank
set.
you.
Okay. With that having been said, then, counsel and Mr. Silver, at my request, have pre-marked their exhibits. A exhibit list has been prepared by the monitor. Appears that plaintiff exhibits 1 through 11 are full exhibits by agreement. Defense exhibits A through C are in fact marked for ID purposes. Counsel, you received a copy of same?
Yes, Your Honor.
Mr. Silver, you received a copy of same.
Yes, Your Honor.
Okay, that being the case, you be seated. Town of Belmont, you may proceed.
The Town of Belmont calls Steve Paquin to the stand.
Come right up here, sir, remain standing, and counsel will swear you in.
Would you please raise your right hand? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Could you please sit, state your name for the record, and spell your last name?
Stephen Paquin, P as in Peter, A-Q-U-I-N.
Your Honor, may I approach the witness? I have extra copies of the exhibits for him
Sure,
to use,
proceed.
and I have an extra set for the clerk as well. It does have some highlighting on it that's not on the originals.
Okay, that's fine, thank you. These are both copies, the originals are...
The originals are right here, I'm going to hand them to you.
Great, thank you.
Thank you. Mr. Paquin, could you please tell the court what your position is?
Code Enforcement Officer for the Town of Belmont
And how long have you held that position?
since 2012.
And could you give the court just a brief background of your education preparing you to be the code enforcement official?
I have a Bachelor of Architecture degree from New York Institute of Technology, and I am a certified building inspector, commercial and residential, through the International Code Council.
Thank you. Are you familiar with the property located at 216 Farrell Road?
Yes, I am.
And could you please describe that property for the court?
It's a wooded lot with a garage up near the front of the road. Fence around a portion of the property that I'm not sure what's behind it, but it's fenced in and there's been some gardening done, paved driveway.
Could you please turn to what has been previously marked as Exhibit 4?
Yep.
Do these photographs accurately represent the property?
Yes, they do.
Now, who owns the property at 216 Farrell Road?
Mr. Sylvia?
And will you look at Exhibit 5, please? And that is the tax card for the property, is it not?
Get there. Yes, it is.
In 2009, was there an event at this property?
Yes, there was a structure fire of the main building.
And what was the result of that?
The building was a complete loss, and the septic system was condemned failed.
And the garage was unscathed?
The garage was unscathed.
Would you please look at Exhibit 1? Now, representative to the court, this is an email to the town administrator from the assessor. And could you please just read the last 2 sentences?
Jason asked about the well and the septic, and he said the septic was destroyed in the fire. I spoke with Mr. Sylvia, and he confirmed to me that he knew when he purchased the property that it had to be replaced and most likely moved due to the present setbacks.
Thank you. And on Exhibit 5 again, is the loss of the septic system also noted
Yes, it is. About midway down the page.
in the notes section?
Correct.
And what exactly does it say? Could you read it, please?
It says per owner, septic destroyed in fire.
Thank you. So on the property, we have a garage. Since 2009, have any permits been filed with the town to convert that garage into anything other than garage space?
No, there have not.
Would that have been required?
Yes.
Let's look at Exhibit 7, if you would. Now, Exhibit 7 is a portion of the International Residential Code, is it not?
Hang on a second. I'm having a hard time finding this second. Yes, it is.
And could you please turn to Section R105? Would you please just read paragraph 1 for the court?
R105.1 required, any owner authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing systems, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain a required permit.
And why is the International Residential Code applicable in this case?
It is state law.
And would that be RSA 155A?
Yes, it is.
Now, let's also look at the zoning ordinance, which has been marked as Exhibit 6. And I'm going to ask you to turn to Article Article 4, Section E, Certificate of Compliance.
Yep.
And if you could read just the first sentence of that as well.
Prior to the issuance of a building permit or change of occupancy permit, the applicant shall obtain a certificate of compliance from the planning board chairman or designated member stating that the proposed structure, alteration, or use complies with all provisions of this ordinance.
Thank you very much. Getting back to RSA 155A, Mr. Sylvia claims that that only applies to public or commercial buildings. Is that your understanding of 155A?
It is not.
And 155A states that it applies to buildings and structures, does it not?
It does.
And it defines building and structure as that term is used in the International Building Code, correct?
That's correct.
And is the definition in the International Building Code the same as the definition in the International Residential Code?
Yes, it is.
So would you please turn again to Exhibit 7? And I believe it is on page 10 of that exhibit that defines building.
Building. A building shall mean any one or two family dwelling or portion thereof, including townhouses, that is used or designed in the intent to be used as human habitation for living, sleeping, cooking, and eating purposes, or any combination thereof, and shall include accessory structures thereto.
And would you please flip 2 more pages and read the definition of structure?
Structure. That is which is built or constructed.
So based on all of that, if someone's going to do work on the garage structure to convert it into a dwelling, they would be required to get a permit, correct?
Yes, they would.
Now, in Belmont, can someone live in an RV on their property?
Yes, they can.
Is that only in certain circumstances? though?
Yes, it is.
Okay, so let's turn again to Exhibit 6. And I'm going to ask you to look at Article 8, Section C, entitled Temporary Mobile Home Manufactured Housing Permits. And I have highlighted some sections of that for you. Would you mind reading those for the court?
The planning board may issue a permit for temporary use of a mobile home for living quarters by a person for whom a residence is being built or repaired after damage is sustained from a fire or other disasters, provided that such use is shown to be a temporary, expedited, and also that the use will comply with the applicable sanitary and sewage disposal requirements.
And would you turn to the next page? And I've highlighted a couple sections there as well. Would you mind reading those?
Number 3, a septic system and water supply must be in existence and capable of being hooked up to the mobile home manufactured housing. Under no circumstances may physical occupancy occur until both systems are constructed and hooked up to the mobile home manufactured housing. Number 8, a temporary use permit may under no circumstances be extended beyond the 360 days from the date of initial issuance of the permit.
Now, to your knowledge, has the planning board issued a temporary use permit for the use of an RV on this property?
They have not.
And you mentioned that the septic system was destroyed in the fire. Have there been any permits filed with the town to replace or repair that septic system?
There have not.
So, despite having no permits for the conversion of the garage to a dwelling unit or the occupancy of the RV and no septic system, is it your belief that Mr. Sylvia was residing on the property?
Yes, it is.
Can you please explain to the court what you have witnessed that would demonstrate that Mr. Sylvia was living on the property?
Yeah. We do drive-bys as I'm going to other inspections, passing the property. There's, in the winter, the driveway has been plowed. There's cars in the driveway. There's smoke coming from the chimney. Lights on. Just general maintenance of the yard made it look like somebody was living there.
And in fact, have you seen him come out of either the RV or the garage?
I have seen him come out of the house.
Which, the garage or
The garage, sorry.
Okay. Now, how does Mr. Sylvia residing in this property without the proper permits or septic system harm the public?
Well, one, if he is in fact using water in the house and he has no septic, he's polluting the ground that gets into the aquifer, which our drinking water comes from. And the other one is not knowing exactly how that house is built because there's no permits. If there is in fact a need for emergency services to go there, we don't know the environment.
In addition to what you've witnessed, has Mr. Sylvia been representing to various entities that he lives at the Farrellville property?
Yes, he has.
Could you please look at Exhibit 2? Now, this is a printout dated April 25th, 2019, from the New Hampshire General Court regarding Representative Michael Sylvia. Can you please identify what he lists as his home address according to the General Court's website?
Yes. 216 Farrellville Road, Belmont, New Hampshire, 03220-3633.
And could you please turn to Exhibit 3? This is a copy of the domicile affidavit that Mr. Sylvia filed on June 7th, 2018. Could you please identify what he listed as his current domicile address?
216 Farrellville Road, Belmont, New Hampshire, 03220.
And down below Mr. Sylvia's signature and above the certification, I've highlighted a section of the form. Could you read that as well?
Yes. In accordance with RSA 659:34, the penalty for knowingly and purposefully providing false information when registering to vote or voting is a Class A misdemeanor.
Thank you. Now, Mr. Sylvia has been residing at the property since approximately 2011, as far as we know, correct?
Correct.
Why hasn't the town pursued an action against him before 2017?
Yeah. When I first came to the town in 2012, there was a selectmen's meeting and we discussed multiple properties in town that had violations and needed to be cleaned up, and it was deemed that there were other properties that were more hazardous that needed to be dealt with first.
And did you in fact deal with those first?
I have.
And then at some point, did the selectmen ask you to address the situation at Mr. Sylvia's property?
Yes, they did.
And was that in about 2017?
Yes.
Now, once you were instructed to pursue an action, how did you proceed?
Same way I do in every other enforcement agent. Letters were sent to the owner.
And are those exhibits 8, 9, and 10?
Yes, they are.
And did Mr. Sylvia respond to any of these letters?
Yes, he did.
In any of his responses, did he deny that he was living at the property?
No, he did not.
And after you weren't able to get anywhere with Mr. Sylvia on your own, did you eventually refer the matter to our office?
Yes, I did.
And could you please look at Exhibit 11? And is that a copy of the letter I sent Mr. Sylvia before we began this litigation?
Yes, it is.
And throughout the course of this litigation, to your knowledge, has Mr. Sylvia ever denied that he resided at the property?
No, has not.
To your understanding, does he live there now?
No.
And your understanding comes from?
His word that he has rented a place over on Route 3.
Does he still use the property?
Yes, he does.
How does he use it, to your knowledge?
I believe he's using it as little headquarters for his running that I see him doing just about every day.
And do you have a concern about the continued use of the property, even if he's not residing there?
I do.
What is that concern?
The use of the plumbing fixtures.
And why is that a concern?
Again, there's no legal septic, so all he's doing is contaminating the ground that we get our drinking water from.
So what is the town asking the court to do here?
We would like to have the use of living there stopped, plumbing, use of the plumbing fixtures removed and stopped, and a new septic put in place.
And is the town also seeking attorney's fees and civil penalties?
Yes, they are.
I have no further questions, Your Honor.
Thank you, Mr. Sylvia.
Thank you, Your Honor. Mr. Paquin, have you ever had a complaint from a citizen about the defendant's property?
I have not.
And you discussed properties in 2012. Was the defendant's property discussed in that 2012 meeting with the selectmen?
Yes, it was.
Do you have any evidence to support that?
I do not have the meeting minutes of that meeting, no.
Is there a permit required for a person to have an RV parked on their property?
There is not a permit, but it's regulated by our ordinance depending on what the use is going to be. So it is something that is followed up through my office.
What evidence do you have that the defendant was residing in the RV?
Sitting in the driveway with the stairs down, the doors open, windows open on it. Pretty confident that somebody's been using it.
Would it be unusual to air out an RV that was not being used in the summer?
No, but stairs probably wouldn't be down on it at that time. Windows may be open, but stairs certainly not down all the time.
Now, an RV can be used, according to the ordinance, for up to 30 days of the year. Is that correct?
30 days within a calendar year, correct.
So how many days did you observe doors open, windows, and possible residency happening in that RV?
I'm not sure the exact number of days, but it was throughout the course of the summer.
Can we get a wild guess as to the number of times you saw what might be the defendant living in the RV?
I would probably say that I drove past the property more than 30 times in the course of the summer and witnessed the windows and doors open.
30 times?
I drive that road quite often with the amount of construction that we have going on in town.
And the doors and windows were open
the
on
units-
those 30 days?
Yes. There was evidence that the RV was being used.
Did you make any notations that the RV was being used at the time?
No. As I'm driving by, I take mental note and I like I do with any other property, I follow it up with the letters that I send to the homeowners.
And was this observation of yours every year from 2012 through 2018 that you saw 30 days of the defendant possibly using his recreational vehicle?
Since my first letters went out to you, it probably got diminished throughout the summers, but prior to 2012, I'd say to 2016, yeah, it was pretty constant.
And how many RVs do you guess are in the town of Belmont that may or may not be used for 30 days or more?
There's quite a few that are used, and they are under enforcement through my office.
And so you observe these RVs and make mental notes of all of them during the course of your travels.
Yes, I do.
Have you traveled recently along Route 3 where there's a storage rental storage space across from the Osborne's Agway?
Objection, Your Honor. Whether or not other people might be violating the ordinance is not relevant to the question of whether Mr. Sylvia violated the ordinance.
Your response, Mr. Sylvia?
You're on a selective prosecution here.
Your response, counsel.
Your Honor, there's been absolutely no evidence that Mr. Sylvia has been singled out for selective enforcement. And selective enforcement requires more than simply going in line and enforcing against one person at a time. It requires some evidence of animus.
Some evidence of what?
Animus, bad faith.
Excuse me, Mr. Sylvia, your response, sir.
I do have support for animus. The town selectmen were on a political witch hunt. They were upset about the county budget. They wrote a letter to the delegation chairman at the county convention. They also had that letter published in the Laconia Daily Sun, objecting to the county budget, of which I was instrumental.
Counsel, your response?
Well, Your Honor, that's testimony, not argument as to why there's selective enforcement. And the fact that the selectmen may have been upset about the budget to lead to the conclusion that they then brought a bad faith enforcement action against Mr. Sylvia is just a leap of faith that can't be made.
The alleged leap of faith is documented in the select board minutes of July 31st, 2017, where the defendant had written a letter to the select board. The letter was noted in the minutes, and in the non-public session, of which might be questionable, they discussed the neighboring property of Mr. Griffiths, and then continued on to discuss the action against the defendant.
Anything further, counsel?
Again, Your Honor, that is not evidence that Mr. Sylvia was singled out. His property is right next door to Mr. Griffith's. It makes sense that if the selectmen were discussing Mr. Griffith's property, they would also discuss the neighboring property.
Mr. Sylvia, anything further, sir?
I may be a coincidence theorist, Your Honor.
Okay, that having been said, I'm going to allow that question, the witness to respond to that question with that limitation of that particular question, okay? So you may respond, sir. Do you remember the question?
I do not.
Please state the question, Mr. Sylvia.
The storage area across from Osborne's has an RV that's been there all summer. Have you noted that? And questioned the use of it?
The RV it has been noted at that property, and that property is allowed to have outdoor storage of RVs as part of the storage unit as other storage units in the town of Belmont.
And this particular RV is not stored, it's in use for the whole summer.
Then I have not noted that it's being used, no.
Okay. So is part of your claim that the defendant is running a campground?
It is not.
Just that you suspect that the defendant is using it as a residence?
Using the RV as a living establishment, yes.
Do you have any, in your observations, it would seem that you would want to note whether or not there is a water attachment to the RV or a septic outlet from the RV. Those things might be visible from the road. Can you speak to either of those?
I am not questioning the septic coming from the RV, I'm questioning the septic coming from the garage.
Okay, so you are saying there is no water or septic with the RV?
Not that I can physically see, no.
Now then, as far as the garage, what do you know about any modifications to the garage?
I don't know of any. I have not been on the property to witness anything, and there have been no permits.
So, is there any evidence that you have that would support the idea that there is plumbing attached to the garage?
Based on somebody using a property for as often as I see the vehicle in the driveway, I would have to say that there's plumbing in the building, or you're taking several trips to go someplace.
So you're just on pure speculation here?
Correct. I was not allowed onto the property as my letters requested.
And the septic was never attached to the garage as far as you know?
As far as I know, no, there'd be no reason why a septic would be attached to a garage.
And how often did you see, observe the defendant using the garage which you suspect to be a residential use?
I don't have an exact number. Again, I drive by the property several times through the course of the week.
And you testified that you saw the defendant leaving the garage at one point?
There were several times that I've seen you come out of the house, yes.
Garage?
Garage.
Several times. How many is several?
Again, I don't have an exact number. Yeah, I don't keep track of the number of times that I pass somebody's house.
So prior to 2017, when this action started, you were making observations of the property?
I was, yes.
But you were not recording any information for the purpose of bringing an action against the defendant?
No, it was not.
So how concerned were you that there was some sort of environmental damage happening?
Your property has always been, from the day that I went to the selectmen asking about enforcement of several properties, your property has always been on the back of my mind that it's going to come up sometime. And it happened to do that in 2012. It's always been a concern.
So from 2012, when you first had your suspicions about the possible residential use of the defendant's garage, this being an irreparable harm, according to the seeking an injunction, you made no notes of how often the defendant was at the property, and yet you were concerned.
Correct.
How often did you observe the defendant at the property overnight?
My shift stops at 4 o'clock in the afternoon, but on several occasions, a handful of times, I have driven by your property at night. Your car is there. An exact number I don't have.
So a car parked in the driveway leads you to assume residency?
The fact that the only car that I see you driving in is the one that's parked in the driveway of the garage would make me assume that you are there when the car is in that driveway, yes.
And yet you don't know how many times after your normal hours you were in Belmont observing the property?
No, I don't have a number of times throughout the last 5 years that I've driven past your property.
Do you recognize the Constitution of New Hampshire as being the law of the land?
Objection, Your Honor. Relevancy?
Relevance, Mr. Sylvia?
Your Honor, the defendant has a right to privacy. If a government official is observing that person, then one can assume that they are violating that person's right to privacy.
That's a legal argument, Your Honor, not a proper area of inquiry.
Objection sustained, Mr. Sylvia. Continue, sir.
So you have no evidence of alterations of the property. You have no evidence of water use in the property. Do you know anything about a well on the property?
I do not.
Now, you are an expert on the building code. Are you familiar with the statutory history of the RSA 155-A?
Objection, Your Honor. Mr. Capeland is not a legal expert.
Mr. Sylvia, your response, sir?
Mr. Pickman is an expert in building code. He has testified to the building code being a legally binding area. That testimony relies on a legal determination.
Your Honor, that testimony relies on the present version of RSA 155A. Its legislative history has nothing to do with what it currently states.
Mr. Sylvia, any further, sir?
Mr. Pickman, being a professional, one would think
Is there something specifically in the legislative history that in fact you're concerned with? If that is the case, then if you want to ask him about that specific concern or that particular topic, then I'll allow it. So if there's something in the legislative history of this particular statute, then I would like to proceed, sir.
Thank you, Your Honor. What is the reasoning behind building codes?
Public safety?
Public safety.
Right.
And are you aware that when this statute, RSA 155, was initially brought out of the 155, which referred to factories, tenements, other such public places, that the first version of RSA 155 had as its subject schools, halls, theaters, and places of public accommodation which would accommodate more than 100 people.
I'm aware of that, that's how it started, but that's not the RSA that I'm currently enforcing by.
Once again, do you recognize the Constitution of New Hampshire to be the law of the land?
Your Honor, I renew my objection.
Anything further in your response, Mr. Sylvia?
Yes, Your Honor. The defendant, being one of the people of New Hampshire, is protected by Part 1st, Article 2, to his life, liberty, and property and the enjoyment thereof. Statutes which extend beyond their proper role into a violation of Part 1st can only do so through the doctrine of the police powers of the state. Any law that would be written or applied incorrectly, which is the presumption here, then that statute misapplied cannot defeat the law of the land, our Constitution.
Again, Your Honor, this is a legal argument, not an area of inquiry.
Objection sustained. Your next question, Mr. Sylvia.
So you've seen evidence of photographs of the property,
Yes.
and those photographs cover basically the front of the property and the garage.
Correct.
And in the tax record, I believe there's approximately 8 acres of land, wooded land.
That is correct.
And have you surveyed the 8 acres of land?
I have not.
So you are only familiar with what you can see from the street?
Correct.
So can you say with certainty that in that wooded lot, there is not an old camp with which the defendant may have spent time?
No, I do not.
If there were an old camp, would the defendant be required to tell you about the place?
No.
So, are you familiar with Henry David Thoreau?
Objection, Your Honor, relevance.
Relevance, Mr. Sylvia?
Relevance, Henry David Thoreau, well known for living in a shack in a Walden Pond for 2 years.
Objection sustained. Continue, sir.
So now, we're here with no actual evidence of the defendant doing the harm that you claim. Essentially, you're concerned with septic in the groundwater.
I'm not sure if there's a question there or not.
It's not yet.
Okay.
I'll withdraw my non-question. With regard to Article 4E in the ordinance that you previously read,
The certificate of compliance?
yes, thank you.
Just what exhibit do you refer to specifically?
I'm
Mr.
sorry,
Sylvia?
Your
It makes
Honor.
the record more complete. You have a list of the exhibits there, so.
We do, I'm trying to,
It's Exhibit 6, Your Honor.
Exhibit 6, you agree with that?
Exhibit 6, yes.
Thank you.
So this particular section of code says the applicant shall, twice. Has the defendant applied for anything from the town?
You have not.
So how would this section be applicable to the defendant?
If you were using your garage for anything other than a garage, you would have to be in compliance with it.
This, once again, states the applicant shall. The defendant is not the applicant, is that correct?
You become an applicant when you want to do something to your property.
And you further testified, pardon me, that the International Building Code find my exhibit number. Exhibit 7. On page 1, R202.2.
I'm sorry, page 1202.2 or 102.2?
Oh, I'm sorry, 102.2? I should put my glasses on. Sorry. Are you with me?
You're on section R101.2.
102.2
102?
says other laws.
It's on the first page.
Yep, okay.
Now, you testified that the building code is applicable to the property, and 102.2, saying other laws, reads, "The provisions of this code shall not be deemed to nullify any provisions of local, state, or federal law." Can we assume that means you cannot overrule the Constitution?
I'm not really sure how to answer that. I'm following state law.
Is the New Hampshire Constitution state law?
Sure, part of it.
The foundation of it, perhaps?
Yep.
I'm approaching the end.
Excuse me?
I'm approaching the end, I just don't
Oh,
want
I
to make sure I
see.
do this stuff. Now, were you present at the meeting with the Select Board on July 31st, 2017?
I do not believe so, no.
Exhibit 8, your letter to the defendant, August 16th, 2017. You describe at a recent Board of Selectmen's meeting while updating them on my office's recent enforcement. Can you tell me about the discussions that occurred in that meeting? And what that meeting date might have been?
Prior to any board meeting with the selectmen, I sit down with the town administrator and discuss the actions that are within my office so that the selectmen are up to date if taxpayers come in and have conversations with them. And that's what happened prior to this meeting, is I updated the town administrator with the actions of my office.
believe I'm done.
Okay, thank you, sir. Counsel, any further questions?
Briefly, Your Honor.
Proceed.
Mr. Capeland, do you have to have a complaint to bring an enforcement action against a property owner?
I do not.
But do you need the assent of the selectmen to do that?
I do not. Well, depending on the violation of the property, I will bring it forth to them first, yes.
Would you look at Exhibit 6? And it's page 8-12. This is the zoning ordinance. And it's Article 8, and the section is entitled Recreational Vehicle Use.
A little messed up here. Page 8-12?
Yes.
Yes.
Recreational vehicle uses.
Yep.
Section B, would you read the first sentence, please?
Property owners may house one unit on their property as accessory to an existing primary residential use, providing the intent is to store the unit or to use the unit for temporary recreational use of the property owner or non-paying guest.
Is there a primary residential use on this property?
There is not.
So is Mr. Sylvia permitted to have a recreational vehicle on the property?
No.
Mr. Sylvia suggested that this entire case is based on speculation. Would you say it's speculation or observation and conclusions?
Observation and conclusion.
Mr. Sylvia suggested that the septic system might be attached to the garage. Even if the septic system were attached to the garage, if the septic system was destroyed in the fire, does it matter?
No.
Mr. Sylvia also suggested that somewhere on these 8 acres, there might be an old camp somewhere that he's residing. Would you please look at the tax card that's been marked as Exhibit 5?
Maybe.
That's exhibit what, Counsel?
5. Is there anything on that tax card that reflects somewhere on the property there's an old cabin?
There is not.
If there was an old cabin on the property, would you expect it to be on the tax card?
Yes, I would.
Do you have any reason to believe there's an old cabin somewhere on that property in which Mr. Sylvia is residing?
I do not.
Thank you. Any further questions, Your Honor?
Mr. Sylvia?
What direct knowledge do you know of the preparation of that tax card?
It's my understanding that the tax cards are developed through an outside agency that does the assessing in our town.
Do those who prepare the tax card survey properties to see what's in wooded areas?
It's my understanding that when an assessor goes out to a property, they look at the entire property for what is on that property.
Your understanding?
Correct?
Did the assessor that came to see the defendant's property walk that property to see if there was something other than what is on the tax card?
I don't know. I don't know if he walked your property or not. It's my understanding that they look at the entire property when they do their assessment.
And once again, you don't know that there is any showering going on in the RV. Is the regulation under which the counsel, the plaintiff, asked about the use of campgrounds, the use of property to park a recreational vehicle, is that not under the regulations for campgrounds?
It's under that section of the ordinance, yes.
And so that would apply to campgrounds
Not necessarily. It clearly states that it's a property owner with a primary structure. That it's not necessarily tied to a campground. It's just under that section.
Thank you, Mr. Sylvia. Any further questions, counsel?
No, Your Honor.
Thank you, sir. You can step down. Belmont's next witness?
Your Honor, I'd like to call Mr. Sylvia to the stand, but I suspect we're going to have the same conversation we had last time I tried to do that, so let me try to do it. Mr. Sylvia, I'd like to call you to the stand.
I would invoke my Part First, Article 15, right not to incriminate myself.
Okay, why don't you stand, sir? If you
Oh, I'm
could.
sorry, Your
No
Honor.
problem. Go ahead, sir.
I invoke my Part First, Article 15, right not to testify in criminal or civil matters.
Okay. That having been said then, do you wish to argue his invocation of his Fifth Amendment rights, counsel?
Well, if he's invoking his Fifth Amendment rights, no, I don't have anything to argue about that. If he's invoking some right not to be able to, not to have to testify in any civil matter, I'd like to see the section of the Constitution to which he is referring.
Well, civil testimony can be used. In fact, it would imply his, or involve his Fifth Amendment rights, correct?
Again, if he's asserting his Fifth
I
Amendment
assume
rights.
that's what you're asserting, sir.
5th and 15th of the New Hampshire Constitution.
And again, consistent with the applicable standard as reviewed in State v. Wheeler, State v. Richards, and the federal constitution, federal law, I must be perfectly clear for review of all surrounding circumstances that this invocation is inappropriate, okay, or in fact is not based on a proper understanding of the law. Can you provide any argument to that effect?
I cannot, Your Honor.
I'm going to find then the invocation is appropriate under the applicable standards. Accordingly, your request is rejected based on Mr. Sylvia's invocation of his constitutional rights. Any other testimony?
No other testimony, Your Honor. I would have this request. I anticipate that Mr. Sylvia is going to make some arguments.
He can testify, and I assume if he doesn't wish to testify, I'm going to allow him to make oral arguments, yes.
If he is going to make factual representations during that testimony or his argument, I think it should be subject to cross-examination, and that is the only request I would make.
That indeed is consistent with the appropriate administrative order. I believe it's Administrative Order 15.
Thank you, Your Honor.
If in fact offers of proof are made, and in fact the witness must be subject to cross-examination.
Thank you, Your Honor.
So at that point then, anything further, counsel?
The town rests, Your Honor. I do have a proposed order.
Thank you, counsel. Just submit that at the end of this hearing.
Certainly.
That being said, Mr. Sylvia, other than what's been pleaded, or in fact you've submitted as pleadings, do you have anything further, sir?
Your Honor, the town of Belmont has put forward no evidence to support their case, and I would move the court to grant summary judgment in favor of the defendant.
Okay, sir. Anything else? Do you have any written submissions other than what you provided already, sir? You don't have to say, I'm just giving you that opportunity. Do you have any other written submissions?
I submitted a memorandum yesterday.
You did? Okay. That having been said then, why don't you submit your findings?
Certainly.
I'll take the matter under advisement.
Thank you, Your Honor.
Copy it to Mr. Sylvia.
Of course.
Okay, thank you. All the exhibits are in the possession of, in fact, I have all the exhibits, so. As I indicated, I'll take the matter under advisement. Court recesses. Thank you very much.
Thank
Court
you.
rise.
So we're outside of Belknap County Superior Court here with State Representative Mike Sylvia. Just walked out of a civil trial where the city or town of Belmont is coming after you because they're alleging that you are living in an RV and or garage on your property. And what amount of fines have they hit you with at this point for this?
Their idea is to charge me $275 a day from the time they sent out their first letter.
Which was when?
2017. The judge already rejected that in his previous preliminary injunction hearing, which was about a year ago. In that case, he said that the fine was deferred pending the trial and the outcome. So
So when they hit you with it, what did it amount to? I mean,
Oh, at the time, I think it was $120,000.
$120,000.
That was last year. So I guess it's up to probably 200 plus now.
So, but the judge said it was abated, or
it was deferred.
deferred.
Yeah, I think it was deferred.
Meaning that if you're found responsible, then they're going to try to collect that?
I think mostly what it meant was they didn't have proper notification in order to get that $275. And the statute says shall be subject to a $275 fine, but there is law
Per day.
but there is law that abates the shall because legalese can get rid of anything. So there is something about subject to that I read in one of the legal findings that subject to modifies the shall, and it essentially turns it into an optional thing.
You're saying that you think that the fine might be optional?
Depending on what the judge wants to do with it, yes.
I see. So the judge could impose, the judge has the option, is what you're saying? Not,
Yes.
Okay.
Well, the town certainly doesn't have to.
Well, yeah, the town could have done nothing, obviously.
Right. And the town offered to drop it
Prior to trial,
prior to trial as part of a deal.
and you said no.
I said no, legal fees.
And part of their offer was that you would have to jump through their hoops and get permits
Of
and
course, like all
be obedient.
all the compliant people, yes.
And so you said no, you went to trial. The judge took it under advisement, which means he'll make a decision later.
Right.
Obviously, you probably don't have any idea what's going to happen, but worst case scenario, they find you responsible. The judge could then impose $120,000, $270,000. What's the value of the property, if you don't mind? What did you pay for it?
It was just reassessed at $58,000.
Right, because the house burned down before you bought it.
There's no house there.
Right, so they would, if they assess that, then they would probably have to steal what you thought was your property from you.
Yes, it's not going that way. I think that the judge knows enough probably background from this that this is a political assault, and it's just as simple as that. What I didn't expect, I thought there might be an opening statement, which I had prepared, and it would have been a good one, but we didn't have that. So
Shoot.
certainly trimmed the length of the trial, so I'm happy for that. It's a sunny day, and
Yeah, it's a pretty nice day
we
here.
get out for lunch.
All right, well, I won't keep you. Definitely let us know how it goes, and we'll let folks know how this is
We'll do,
developing.
standing for the property rights of all.
Thank you for doing that, Mike. Really
pleasure.
appreciate your time.
We'd like to invite you to visit freekeen.com. Freekeen.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeen.com also has comments and discussion forums so you can be heard. Freekeen.com.
I should be in Keene, New Hampshire with the Free Staters.